Good afternoon, everybody, and welcome to the Taylor Wessing Senior Manager's Survival Guide. I'm Alix. I'm a partner in Financial Services team here, and I'm here with Paul Callaghan, partner in Employment. And today we're going to be talking to you, as the slide says, about regulatory and consequential employment implications of the Senior Manager's regime and how it's going to affect you and your business, and what this means for you and your employers, and your employees and your senior managers. And this is a combination of technical changes, so rule-driven changes, and human relations and employment law implications. We're going to try and talk you through some of the impacts and some of the solutions. So I'm going to talk to you about the origins and timetable of the new regime, what the senior manager's regime is. So these are the three planks of the changes: the senior manager's regime, the certification regime, which spreads out this more broadly, and the conduct rules, and flag up some upcoming changes which will not be enforced as of 7th of March. So here looking at really the origins of where this happened. So in June 2013, the optimistically titled Changing Banking for Good report of the Parliamentary Commission on Banking Standards was published, and this really pointed to a lack of accountability as being a fundamental driver behind various banking scandals. And this resulted in the Financial Services Banking Reform Act 2013, which is the legislative framework for the changes we're going to be talking about. And this made amendments to the Financial Services and Markets Act. Also in June 2015, the PRA and the FCA, the two responsible regulators, published a joint policy statement on strengthening the alignment of risk and reward, and that was the remuneration rules, and they backstop what's going on here with senior managers. We're not going to be talking about that today, but it's obviously an important part of the piece. And in June 2015, the Fair and Effective Markets Review published its report on raising standards in fixed income, currency and commodities markets, so the wholesale market. And the Fair and Effective Markets Review wants to see similar changes in those markets. Final rules, or really semi-final rules, were published by the FCA and the PRA in July 2015. Which leads us on to where we are now, which is the timeline, what you've actually got to do. So the first date was Monday. You had to get your grandfathering notifications for senior managers who are already approved persons in so they can transition across. 7th of March 2016, two things are happening. The senior managers and certification regimes are in force. And that means that you've got to have identified and trained your staff who are subject to the certification regime. The 7th of March 2017, and the conduct rules will be enforced then as well in some senses. In 7th of March 2017, we're going to be seeing a wider application of the conduct rules really across the bulk of your staff. And on that date as well is the deadline for issuing certificates to your sort of essentially self-certified staff. And in 2018, the Treasury is looking at really extending this regime. We'll talk about this a little bit later. No, there we go. So looking at the first plank of the regime, this is the kind of the top tier of the regime. This is the senior manager's regime. And this is an accountability regime covering individuals in banks, building societies and credit unions and PRA-designated investment firms. These are the very large banks, and there are 9 of those. So what's a senior manager? A senior manager is someone holding a key role or an overall responsibility for a whole area. And a senior manager is still subject to regulatory pre-approval. So the senior management function is defined in 59ZA of FSMA, and that, in summary, any function relating to the carrying on of regulated activities if the function requires the person doing it to be responsible for managing one or more aspects of the firm's affairs, and those aspects involve or might involve a risk of serious consequences for the firm or for business or other interests in the UK. So this is replacing the current approved persons regime, though you will see, of course, that the forms look rather similar. So these are the people who still have to send in a form, an application, before they become approved by the relevant regulators. What the regulators have both said is that this is really aimed at the top slice of management, the people who are ultimately responsible. So they anticipate the number of actually paper applications diminishing because this is supposed to be a smaller subset. So, moving on, the thorny subject of statutory duty. Is there a statutory duty? Yes, there is. There is a statutory duty on senior managers to take reasonable steps to prevent regulatory breaches in their area of responsibility. This statutory duty was announced by the Treasury in October 2015 and is a dial back from what had previously been an attempt to legislatively reverse the burden of proof. So the previous iteration had made senior managers liable if they could not show the regulator that they took steps that it was reasonable to take to prevent the breach occurring or continuing. Excuse me. So that reverse burden has itself been reversed. So what are the senior management functions? The senior manager's regime itself, I think it's important to say, has no territorial limitation. So firms must allocate responsibilities for all activities and business areas and management functions across the whole firm, and that includes overseas branches. So the regime applies to entities rather than groups, so you must capture those who are genuinely responsible for the function in the entity concerned, regardless of whether that person is employed by that entity or indeed physically located with them. So there will be cases where an individual is based overseas and employed by another group company but has responsibility for a UK function. And generally speaking, in that case, that person will need prior approval as a group senior manager, group entity senior manager, which is SMS 7. So what do you need to do first? Well, you first need to work out what are the main business activities that you need to cover. And this is going to be specific to your organisation. So the FCA, and the reference we've got here is to CISC 4.5.1, but if you look at CISC 4 Annex 1, they give you an indicative list of the main business activities and functions that potentially need covering. This is not complete, and firms must satisfy themselves that their own list, which they really need to come up with on their own, covers the business that they conduct. So this Annex 1 should be used as a kind of a checklist. It's pretty comprehensive, though. I think you would struggle to find many functions that require a senior manager allocated to them that falls outside this list. So the senior management functions themselves, between the between them, the FCA and the PRA have come up with 20 senior management functions, all of which require pre-approval by the regulators. The requirements are supposed to be applied proportionally, so you apply them to the business that you run. So if you don't have to have a remuneration committee, but if you do and it has a chair, that person will need to be approved as a senior manager in the appropriate function. Some functions obviously apply across all sizes of relevant firms, so like chief executive, SMF1. Some functions are only required for certain firms, as I've just discussed. So if you have a nomination committee, you'll need a chairman function, SMS 13. Some functions can only be held by approved non-executive directors rather than the executive. So that's the chairman function, SMF 9, the senior independent director function, and that's 14. And if you have these committees, the chairs of the risk, audit, remuneration and nomination committees. Other NEDs do not require senior manager status, and the FCA does not expect that a NED would ever perform what's called the overall responsibility function, which I'll talk about in a minute. So where you're a NED that doesn't require pre-approval, you're going to become something called a notified NED, because your appointment has to be notified to the regulator. You notify it after it's happened. Your firm still needs to be satisfied that the NED is fit and proper, but it's a notification, not a request for permission. This leads to quite an odd result, that you have many notified NEDs who will not be subject to the senior manager's regime, the certification regime, or therefore the conduct rules, but you could have many more junior staff who are subject. So the government has said that in its bill to extend the regimes, and this is their paper, the Treasury's paper in October, so when they come to their bill to extend the regime across the financial services industry, and again we'll cover this in a little while, the regulators are going to be provided with the means to make the rules of conduct apply to the NED, so that you don't have this slightly counterintuitive gap. The PRA only applies requirements to a limited number of NED roles, but it requires all members of management to observe certain of the conduct rules, and that's conduct rules 1 to 3, and senior management conduct rule 4. So NEDs, PRA NEDs are going to have to demonstrate, and none of this is surprising, integrity, skill, care and diligence, and be open and cooperative with regulators and make appropriate disclosures. So in addition to all of the functions we've just been talking about, other individuals with something called overall responsibility who do not have a specific senior management function must be identified. You don't have to assign overall responsibility for a senior management function that is required or allocated. So what do we mean by overall responsibility? So overall responsibility is described at CIST 4.711. And somebody with overall responsibility is the person who has ultimate responsibility under the governing body for managing or supervising that function, and primary and direct responsibility for briefing and reporting to the governing body about that function and putting matters for decision about that function to the governing body. So to the extent an individual has overall responsibility for an area, so a business area that you determine needs coverage, but they don't otherwise have a senior management function assigned to them, that person needs to be pre-approved for SMS 18, which is called Other Overall Responsibility Functions. Examples of this could include heads of HR and IT, as well as anybody who's got responsibility for a business line that's not yet requiring approval as a key business area head. Overall responsibilities do not capture NEDs, but they are entity-specific, so the firm must identify who is genuinely accountable whether or not that person is employed by another group entity. And some of you may well be interested in the FCA's recent statement that's going to consult on the extent to which a person in charge of the firm's legal function could require approval under the other overall responsibility function. So that's a possibility that they have floated. It would be interesting to see how this would work alongside legal privilege, because if they were approved under a senior management function, they'd be subject to the conduct rules, one of which is to be open and honest with the regulator and to notify them of anything that they might reasonably expect notice of. So how would a legal function's obligations to be transparent work in relation to privilege? So the FCA is clear, the regulators are clear, that in setting out the responsibilities it thinks are likely to feature in firms, it's not telling firms how to allocate those responsibilities amongst management, so firms have to do this in a way that suits their business and their size. So you've determined what your business looks like, you've determined who's in charge, who's senior management, and now you've got to allocate them their prescribed responsibilities. So between them, the FCA and the PRA have come up with 30 of these that have got to be mapped to those with senior management functions. Some responsibilities are required by both the regulators and some by just one. Some are for assignment to executives and some are for assignment to approved NEDs. So again, not all are going to be relevant to all firms, and the regulators have set out, they've grouped them, how the responsibilities can apply across different types of firms. So in all firms you'll have functions like responsibilities like overall responsibility for the firm's policies and procedures for countering financial crime risk, responsibility for performing your obligations under the senior management regime. So these are kind of broad brush responsibilities. So larger firms, there are certain prescribed responsibilities. So for example, responsibility for leading the development of the firm's culture by the governing body as a whole, responsibility for overseeing the development and implementation of remuneration policies and practices in accordance with the remuneration code. With the larger firm set of responsibilities, there is a subset which must be held by approved NEDs rather than the executive. And then there are small firm prescribed responsibilities. And small firms are those with gross total assets of 250 million or less. So those are responsibilities like responsibilities for managing the firm's financial resources or for ensuring the governing body is informed of its legal and regulatory obligations. So the FCA has tailored its approach to small firms in order to tally with the PRA's list of 8 functions for smaller firms, and they've merely added on the single prescribed additional responsibility in regard to financial crime. And then there are certain prescribed responsibilities that apply in specified circumstances only. So, for example, responsibility for proprietary trading activities if you do it, overall responsibility for compliance with CAP if you do it. So just a quick note on whether responsibilities can be shared, and Paul will talk a bit more about this. Yes, they can. The regulators are clear it's in limited circumstances. And firms must be sure that when people are sharing things that no gaps arise. Shared positions need identical statements of responsibilities. Again, we'll talk about that in a minute. And when a firm contravenes a relevant requirement in an area where responsibility is shared, the senior managers involved will be jointly and severally liable, regardless of who was on watch at the time. So looking at what's the firm's obligations in relation to senior managers? Well, first of all, as we talked about, you've got to map out your own business activities and functions. So you can use the FCA guidance at CISC 4, look at your own business and decide what your main business activities are. Identify all of the entities in your group that are caught by the regime. Does your group allocate responsibilities over one group entity to an individual in another group entity? All of this needs mapping. Is any particular key business area significant enough to require someone to be approved as head of a key business area? And a key business area is one with gross total assets of 10 billion and more than 20% of the firm or the group's total revenue. So you then need to identify the individuals who hold these core senior management functions. So those are 1 to 17. And then you need procedures in place to assess the fitness and propriety of these senior managers before you put their application in. And then you need to make an assessment again of the same individuals at least annually. So you then need to go on to allocate the prescribed responsibilities, and the FCA's SUP 10C talks a bit about this. You need to identify what prescribed responsibilities are relevant to your activities. You've got to allocate clearly, and you've got to make sure there are no gaps. You've got to draw up a responsibilities map. And if the responsibilities map allocates joint responsibilities, you must explain why. You need to think about responsibilities outside the normal course of your business that might need to be allocated. For example, have you got a one-off, high-profile project that will have impact but isn't yet featuring as a business line? You've got to think about the overall responsibilities that senior managers have for functions, activities, areas of business. These may not always be obviously heads of key business area functions. You need to include those with overall responsibility that we talked about who don't have a specific senior management function, but who nonetheless will require pre-approval and allocation of the SMS 18 function. You then need to train everybody on the conduct rules. And we've got a little note in here again, which is to remind us that the grandfathering deadline was in fact on Monday. So then you need to record the responsibilities, and this is where the individual statement of responsibilities comes in. You've got to summarise your individual statements of responsibilities, and again, Paul will talk a bit more about these. These are important documents from an employment as well as a regulatory point of view. And then you've got to summarise them on your responsibilities map. These maps are described in more detail at COCON 4.5, and they must be consistent with the statements of responsibility, so you can't have a disconnect between them. COCON 4.5 also gives us guidance on what these maps need to look like for small and non-complex firms, and then here they're saying, what they say in COCON is that these maps must be one document, but they can be in various sections of one document. But what they say with small and non-complex firms is that these are likely to be simple and short and may even be one page. And again, conduct rules. You've got to make your staff aware of the conduct rules and how they apply to them. So the forms. The forms look very much as they did before, but now you have to attach as an annex the statement of responsibility to the relevant form. There are templates for the statements of responsibility. They must be freestanding. They must not cross-refer to any other documents. In the other way, there is a 300 indicative word limit on the amount of free text that you can use to give further detail on each of the responsibilities. The regulators have been quite firm in rebutting concerns about this word limit, and they said that in their view, the statements of responsibility are about recording what a senior manager is responsible for and less about how they're going to deliver their obligations. There's guidance in the rules as to when you need to submit a revised statement, so somebody's responsibilities materially alter. And you should include in your forms any handover material that's available with the form. Paul will talk about this. Handover certificates are now clearly not mandated, and handover material will not always be feasible, but it is often advisable. So the certification regime. The certification regime is not about pre-approval. This is a self-assessment exercise. Firms have got to assess the fitness and propriety of staff who carry out something called a significant harm function. This is staff who pose a risk of significant harm to the firm or any of its customers. So we've got a list here of the functions of the certification regime's coverage. And this is really trying to cover client interaction. The last two, client dealing and algorithmic trading, are very recent additions designed to capture the wholesale function. So material risk takers, a pretty broad brush description, but material risk takers are only caught to the extent that they're subject to the remuneration code. Contractors can be caught if they fall under the definition of employee at CISC 5.2.21G. Policy statements 16.3, which is one we've been talking about, that adds in client dealing and algorithmic trading, has reintroduced the 30-day chaperoned exemption, where somebody can fly in, do their business here, subject to supervision for 30 days and fly back out again. That has gone, it's been brought back in. You can't use that exemption for the material risk taker significant harm function. So quickly on to the new functions of client dealing and algorithmic trading. This is in response to the Fair and Effective Markets Review. Client dealing is advising, dealing, arranging, acting as an investment manager and acting as a bidder's representative in emissions auctions. Because these are new, there's a transitional period until the 7th of September this year to identify and train new staff. The PRA certification regime applies to material risk takers in firms that are subject to capital requirements regulation. That's why they call them CRR firms, but we're back to the same constituents again: banks, building societies, and PRA designated investment firms. The PRA believes that to a certain extent individuals who are classified as material risk takers for the purposes of remuneration should be subject to the certification regime, but they think that not every individual classed as a material risk taker under remuneration rules would necessarily fall within the certification regime. Slightly complex overlap. So territoriality. So certified staff are those who are carrying on a specific significant harm function from a UK establishment or with a client of the firm in the UK from an establishment of the firm overseas. So there's got to be a strong UK nexus. However, this recent policy statement, one on the 4th of February, has removed the territorial limitation for material risk takers in UK firms. That means that if you identify an employee as a material risk taker, then they are subject to the certification regime regardless of where they are located or where their client interactions take place. So what do firms have to do? Well, you need to issue certificates, and that requirement is in force on the 7th of March next year, 2017. The certificates are valid for 12 months, but you can issue certificates for less than 12 months if you need to. Until then, CISC TP5 explains how the certification regime applies. Essentially, they apply COCON in the meantime. The formal certification needs to take place at least annually, so you need to be going back to this year after year at least. So you need procedures for making your assessment of fitness and propriety and for reassessing this annually. Firms are accountable to the regulator for these assessments. So it may be self-assessment, it may not be pre-approval, but you are accountable for the decisions you make based on the systems that you've implemented to decide how fit and proper people are. Now we're on to the last plank of the regime, which is the conduct rules, and these focus unsurprisingly on integrity, skill, care and diligence and the interests of customers, and they replace the statements of principles for approved persons. Initially, these are going to apply to all those who are subject to the senior managers regime and the certification regime. Other staff become subject to these in March 2017. COCON 1.1.2 sets out which other staff are not intended to be covered by this extension in scope. This is people like security staff, reception, invoice processing, personal assistance, IT support. So they are not intended to be captured. And what are the rules? Well, 1 to 5 cover everyone. And these are general rules that we are all familiar with. So integrity, due skill, care and diligence, be open and cooperative with regulators, pay due regard to customers' interests and treat them fairly, observe proper standards of market conduct. Rules SC1 to SC4 apply to senior managers, and these involve taking reasonable steps to ensure effective control, compliance with regulatory requirements and standards, appropriate delegation and oversight, and appropriate disclosures to regulators. And there is plenty of guidance on the conduct rules, including examples of conduct that's likely to fall short. So what do you have to do? You have to train your staff so they know about the conduct rules that apply to them and how they apply to them. You've got an obligation to report to the FCA suspected and actual breaches by senior managers within 7 business days of becoming aware of these actual or suspected breaches. You need Form C when the notification relates to the withdrawal of an approval, and Form D when the senior manager is remaining in post. So it's interesting to note the PRA requires notifications of breaches by PRA certified employees. So it's a broader category within 7 business days, starting from the point that the firm determines that a conduct rule has been or is suspected to have been breached. So the 7-day limit applies to a wider population when the PRA rules apply. For other staff, you need to report actual or suspected breaches annually. And only suspicions that remain open at the time you're making the report need to be submitted. You need Form H, and you need to cover the annual period up to the 1st of October. So the position on reporting under Principle 11 and other significant rule breaches remains the same. I mean, the regulators are very clear these are 2 parallel regimes. So you can't report somebody via a Form C if you think it's a Principle 11 breach. You've got to escalate it appropriately. So just to finish up, a quick look at what's next. Well, regulatory references, again, Paul didn't talk about this. The regulators all found it all terribly complicated, so they put off concluding the new rules on this until the summer. You need to issue your certificates by 7th of March next year. And then, of course, there's the big one. In October 2015, in an announcement that covered a lot of things we've already talked about, the Treasury also announced plans to extend the regime across the financial services industry, and this is going to be due in 2018. And with that, I'm going to hand over to Paul.
Hello, it's Paul Callaghan here. As Alix said, I head up the employment law group at Taylor Wessing, so I'm going to look at things more from the perspective of what an employment lawyer should be thinking and doing, or anybody else who is working with employees who are going to be affected by these rules. So the first issue I wanted to discuss was handover certificates, which Alix referred to. There is going to be a requirement on firms to take reasonable steps to ensure that every new manager is aware of their responsibilities, and it's generally going to be considered good practice to keep up-to-date handover certificates ready for when just in case an employee leaves or falls under a bus, or there is a situation where somebody needs to take over one of the prescribed roles. And anybody who's listening who might be familiar with employment law will, the analogy that I would use in this sort of situation is that if you're taking on a role that is covered by the senior manager's regime, then it's effectively as if you're to be transferred into that role, that suddenly you are responsible for everything that's happened in that role beforehand. So you really need to know what has gone on, where there might be any traps, where there are areas that you need to pay particular attention to. Likewise, a company or a bank that's affected is going to be particularly vulnerable if an employee disappears quickly and doesn't tell them what has been going on. And for that reason, from the employment lawyer's perspective, one important thing to do is that if there are discussions about someone's exit and a potential settlement agreement being reached, it would make a lot of sense to ensure that within a settlement agreement you have a provision ensuring that before any payments are made, a full, comprehensive and true handover certificate is prepared so that the employing organisation can pass that on to the new employee taking over that role. Likewise, if you are coming into that role yourself, you may very well want to have some sort of warranty or indemnity or even insurance cover should it turn out that the handover certificate that you receive is not adequate and you're found to be liable for things that happened before in fact you took on that role. And even under the old current rule, there's the example of Mr. Pottage, who gets a mention on this slide, who was in trouble with the FCA because of things that happened before his watch, and that was even before these rules took effect. So already there's been a move by people in the industry to ensure that there is some sort of indemnity or protection given to them for things that may well have happened before they even joined the organisation. So handover certificates are going to be key. My advice would be that every 6 months or so, every function for which it's relevant should be reviewed, and the incumbent employees should be asked to update their handover certificates to ensure that if anything does happen, if they do leave abruptly, you have something that will protect both the bank and any new person taking over that role. Then moving on to statements of responsibility, which Alix also talks about, and these are going to be clearly an important element in negotiations between senior managers and their employers. From the perspective of the bank, every prescribed responsibility has to be allocated to somebody. From the perspective of the individual, they will no doubt want to be properly remunerated if they're taking on these prescribed responsibilities, and they want to be absolutely clear that the responsibilities they're stated to be taking on do reflect what their area of expertise and what they're planning to do in the job. Therefore, the duties provisions of the employment contract, which will no doubt start to contain these statements of responsibility as an annex, do need to be heavily negotiated, and it needs to be absolutely clear that there's no dispute or disparity between what the employer and the employee think should be the case. Now, Alix has already mentioned that 300 words has been given as a guide as to what is the length of the statements of responsibility. They don't have to be 300 words, it's not a cap, it's not a minimum number of words, but that's just the sort of guidance we've been given. And I mentioned the case of Mrs. Grigg, again, obviously under the existing old rules, but Mrs. Grigg, she was fined by the FCA in a situation where she was accused of something she didn't think was her responsibility. It was something that, in reality, in her job, it was not a function she was carrying out, and she thought that function was meant to be carried out by somebody else. In fact, it might have been in practice within the organisation, but the FCA ignored that, and they actually looked at her job description, and because it contained the function that they determined was being carried out inadequately, she was still fined. That's a very good example of why negotiating the job description and the statement of responsibility are extremely important in a way that may not be for jobs out in other sectors. And also, needless to say, jobs do change, and whenever jobs change, then the statement of responsibility needs to change. Certainly if you were a senior manager covered by this regime, you would want to lose any of those prescribed responsibilities from your statement of responsibility if in practice you weren't responsible for them. You want to make absolutely sure that if they're not within your purview and your control, you're not going to be liable if anything goes wrong for them. Likewise, if you're the employer, you want to make sure that the person you think is doing something actually has that clear express responsibility in their statement of responsibility. So it's something that will need to be looked at whenever there are job changes or promotions, and so it isn't just going to be a case of saying you now have this new role, this is your title. Whenever any changes for relevant jobs do take place, that is going to involve a revision to the statement of responsibility. And what we're seeing in terms of market practice already is, certainly in terms of the grandfathering provisions, are employers allocating or giving some sort of legal fees to employees to allow them to take legal advice, and they are and to help thrash these things out. Job sharing, Alix again alluded to this. Now, job sharing is perfectly possible in relation to any role that relates to these prescribed responsibilities. But the key point is that both people within a job sharing role are going to be equally liable, effectively joint and several liability for any of those functions. So again, well, not only does that, the whole job sharing situation gives rise to potential discrimination claims, because women are more likely to be in a job share role statistically than men. And needless to say, if you are in a job share role, or you have people in a job share role, it's more likely that they will want to have some sort of indemnity should any failing actually be on the part of the other person in the role. Because technically speaking, they're going to be equally liable whether they are in fact to blame or not. And NEDs have been mentioned there. In fact, ultimately, most NEDs have got off quite lightly following the consultation process, and although they are all going to be subject to the conduct rules, unless they do actually have some executive functions, they're not going to be covered by the senior managers regime. So then, moving on to the certification regime, that, as Alix has already said, covers individuals whose role involves a risk of significant harm. It shouldn't be difficult to work out who they are, because those functions have been set out very clearly. There are some emergency appointments for up to 4 weeks where you don't need to be certified if you're in one of those roles, and as you can see from the slide also, if you're carrying out a role for only 30 days in 12 months, you're also effectively let off the hook generally. Now, certification, as Alix has said, is a self-regulating requirement, so the employing organisation themselves need to take responsibility for that. And to decide whether to certify someone, you have to effectively determine whether they comply with the fitness and propriety test. Obviously, you need to check criminal records, and there are new provisions allowing you to do that. Whether somebody is fit and proper, the guidance is quite broad in that there are a number of different things you can take into account. So qualification and training, but then also whether somebody has a professional level of compliance, and also looking at their personal characteristics. So that may well allow people who've been carrying out a particular role for a long time but may not be formally qualified to do it, to carry out that role. But it places a lot of responsibility on the employer to objectively try to evaluate that in every particular case. It does mean more, obviously, it means more bureaucracy, more compliance to go through in the organisation, because everybody in that sort of role needs to be certified or not certified as soon as the rules come into effect, and then every 12 months, because these certificates are only valid for 12 months. Needless to say, again, as with the senior managers regime, if somebody moves role, there needs to be a re-evaluation of whether they should be certified. Records need to be kept to assist you in making a reasonable determination as to whether to renew somebody's certification after 12 months. And then, if you do decide, for whatever reason, that somebody should not be certified any longer because of something that has come to light in the previous 12 months, then it may well be that would ultimately permit a fair dismissal under some other substantial reason of the Employment Rights Act, or MiFID II has also suggested that an alternative would be that person could potentially work under supervision for a period. What you can't do is limit your right as an employer to make the appropriate decisions relating to whether somebody should be certified or not. So a settlement agreement or some other sort of agreement can't be used to potentially to limit your flexibility to do what is appropriate to comply with these rules. And on that theme, similarly, that there are more rules, as Alix said, coming in relation to references for people who are covered by either the certification regime or the senior managers regime. And we are still waiting for a final ruling as to what those rules, what those references need to be like. But it's clear that there is going to be a requirement for more detailed regulatory references for people covered by these regimes. And what that means is that a list of relevant issues will need to be discussed in a reference, in a prescribed form, and it will not be possible anymore for an employer simply to give either no reference or to give a short reference just detailing dates of employment and job title. Much fuller references are going to be required, and for anybody taking on an affected role, they're going to be required to going back 6 years. So clearly there are going to be record-keeping obligations on employers so that they keep records for employees who leave for at least 6 years. And those references also need to be reviewed in the light of new facts. So you can't, in a settlement agreement going forward, potentially negotiate an agreed reference. You can to a certain degree, but it always has to be caveated with that right and, in fact, obligation to change that reference if new facts come to light. Then, finally, talking about the conduct rules, they do cover just about everybody in the business except what is referred to as ancillary staff, and that has to be people clearly who can't influence the success or otherwise of the business. Like the examples given are people working on reception in the post room and in the canteen. Although if the receptionist is rude to your clients, perhaps that does influence the success of your business. You do have until March 2017, however, to prepare for that. The conduct rules are very much encouraged that everybody is notified and trained and records are kept in relation to them, and that a system is put in place for notifying the regulators if there is a potential breach. Now, the conduct rules in relation to everybody except senior managers are quite broad in terms of what they say. They say that you have to act with integrity, due skill, care and diligence in the way you carry out your job. It is limited to your workplace activities, so not what you do in your private life, but obviously if anything in your private life meant that you clearly had a lack of integrity, that could still be relevant. And then for those who are senior managers covered by the senior managers regime, there is this second tier to the conduct rules, which covers a delegation. What it essentially says is that where work is delegated, there is this additional responsibility on senior managers to ensure that it's delegated to an appropriate person. And also, you have this obligation to oversee the discharge of the delegated responsibility. In other words, you have an active supervision obligation under the conduct rule that is being introduced. So that was all on the conduct rules. I then want to touch on a slightly different topic, but something that has come to light, and that is the new whistleblowing rules that are going to be coming into force relatively soon. They're not coming into force at the same time as the senior managers regime, but it's worth being aware that they are due to come in. And just to cover them briefly, essentially what they're saying is that although there will be no regulatory duty on a firm's staff to blow the whistle, every potentially impacted employer does need to put whistleblowing arrangements in place to handle all types of disclosures from all types of persons within their organisation. And as you may know, both the FCA and the PRA already have their own whistleblowing services, and it's going to be a requirement that firms, regulated firms, notify their employees of the FCA and PRA whistleblowing lines and of their right to use those lines. You are going to be required to have your own whistleblowing line too, but you're not permitted to restrict employees from using the FCA and PRA whistleblowing lines only when they've exhausted the internal lines, although you may want to encourage them to use internal processes first. And essentially, everyone who's covered by the rules will have to present a report on whistleblowing to its board at least annually. There's also going to be an obligation, albeit it looks a fairly weak obligation, for every regulated organisation to have what's called a whistleblower's champion. But that it doesn't have to be an executive role, and it doesn't even have to be a formal part of someone's job. So it is quite weak, and that person doesn't even have to have let people know that they're there to hear any whistleblowing, but they do have to be apparently open to letting people, open to people whistleblowing to them if they so choose to do so. And the protection for employees who in good faith do blow the whistle are more significant than under the General Public Interest Disclosure Act protections for whistleblowing that other employees have. In that there is not the limited definition of protected disclosures that you have there. But that was all that I wanted to say on the Whistleblowing Act, or the whistleblowing rules, as well as on the Senior Manager Survival Guide. So from our perspective, do let us know if you have any questions, and email them through, and both Alix and myself will be happy to respond to any particular queries that you do have. So thank you for listening.